Afternoon, everyone. It's a pleasure to be here. As mentioned, today I'm going to be discussing the law of ecocide as a vehicle for universal legal protection in the face of geoengineering. So we've heard from many great speakers today about the complicated and respectively different challenges of these practices. And we also know that the Earth's current face in human history is novel, in which natural elements and human forces are inextricably determinative of one another and their respective fates. We also know that there has been a tangible shift in understanding that we can no longer sustain the illusion of unlimited interference with our finite natural environment, and that our collective planet has a quickly depleting capacity to withhold our actions. Only recent years are seeing growths in environmental law and the protection of environmental resources as intrinsically valuable in themselves, and not only for their human-derived value. However, I would like to emphasize more optimistically that with this evolution, the world faces an unprecedented opportunity to address two problems at once: to mitigate ecological catastrophe, and also to manifestly affirm our planet's vital, natural and cultural heritage. So today, I hope to emphasize that in affirming our inherent interdependencies with the natural world, as well as our collective duties to it, that criminal law can play a pivotal role. As the ultimate sanction, it's very important to highlight that criminal law should only have a restricted field of application, but we must extend our visions beyond theories of punishment to understand criminal law's fundamental role in facilitating coordination around social values that we deem essential. Reconciling environmental law with criminal law in the context of these crises raises complex new issues. However, there are very strong reasons to supplement our existing legal frameworks with a criminal law backstop. So today, I hope to highlight these reasons in the context of ecocide law, as well as universality, before turning to the relevance of such arguments for geoengineering. While there is an impressive body of environmental laws around the world, there is a tangible frustration multi-jurisdictionally with poor enforcement. Arguably, such issues are largely derivative from an absence in law, that unlike human rights, the environment does not have a comprehensive and foundational piece reflecting the severity of violations. More pertinently, the assumption that capital holds the sole solution to the climate and ecological emergencies hides itself from the fact that the causes of the ecological crises are systemic, lying within current patterns of global production, consumption, finance, and the organization of social life. Central to the logic of unlimited growth has been a tendency towards the permission of ecocide, the destruction of conditions that maintain life, such as ecosystems and the commons. It is certain that any actions will result in ecological imprint, and it's undoubtedly important that environmental law acknowledges and reflects competing considerations, such as the right to development in its operation. However, that is principally why it is so fundamental we provide a framework of safety. A sound way to initiate and substantiate our existing legal framework, leading to a greater coordination and enforcement of environmental law internationally, could be well assisted by a parameter that seeks to prevent the severest form of damage, ecocide law. Ecocide law, a preventative and all-encompassing legal framework, can rectify that of an existing taboo in international environmental regulation, that the most serious destructions of nature are morally reprehensible and thus criminally liable acts. Significant global challenges are connected to and exacerbated by environmental crimes and harms, affecting development, peace and security, and human rights. With a combination of huge profits, a low risk of detection, and ineffective penalties, environmental crime is notoriously lucrative. However, perceived as victimless and low priority, such crimes often fail to prompt a thorough and effective approach, when in reality, environmental crimes affect all of society. Similarly, even the supposedly firmest provisions in international environmental law, such as ozone depleting emissions, are moderated in different ways and balanced against other objectives. As I mentioned, flexibility is inherent and essential to environmental law. However, the result is that environmental crimes and harms are typically entangled in a jigsaw of civil regulation, which sees prohibition on the grounds of expediency or regulative violation rather than a moral nature. It is precisely this legal framework which I consider leads to environmental enforcement that is misaligned by both principle and procedure. States remain the primary recipients of the majority of international environmental law agreements, and therefore they must necessarily rely on one another to ensure compliance and enforcement, with a coinciding limitation of opportunities for non-state actors to preserve and enforce international environmental law. Now, I don't suggest that we do away with such frameworks, but I argue that a greater integration of multiple levels of stakeholders in environmental regulation is widely recognized as fundamental. Due to substantive, procedural, and regulatory fragmentation, the bulk of environmental interactions are hidden, when by nature, regulation of these issues necessitates a global and interdisciplinary approach. Therefore, the current sectorial division of offences is not reflective of the complexity of the interrelationships. Repercussions of environmental harms and crimes are transboundary and transgenerational. Therefore, the challenge of legal reform is simultaneously interspatial, global, and intertemporal for current and future generations. It's therefore essential that we propose comprehensive and inclusive legal frameworks that reach a wide variety of actors and preserve rights for nature, humans, and otherwise. According to the most authoritative and widely recognized definition of ecocide, posed by an independent expert panel, the crime is defined as unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term harm to the long-term damage to the environment being caused by those acts. The environment, to ensure all its aspects were conflated into one definition, is defined as inclusive of the Earth, its biosphere, cryosphere, lithosphere, hydrosphere, and atmosphere, as well as outer space. With an express attempt to reflect both existing international environmental law, as well as assist its evolution, the panel definition is a consensus of 12 expert opinions. As Darrell Robinson, professor at Queen's University in Canada, argues, there are principled, normative, and strategic reasons as to why a crime of ecocide should reflect international environmental law and not reject it. Therefore, in this regard, the drafters of the definition were sure to avoid outright criminalization. We don't want to criminalize the ordinary actions of industries that sustain the well-beings of millions of people. Therefore, the three-part conjunctive offense distinguishes from lesser environmental offenses, maintaining the stigma and the gravity that warrants international criminalization. International criminal law's spirit is in establishing a consensus around a value that is presumed universal, and therefore defining ecocide requires the consolidation of values which are or should be shared. As a preliminary point, it's noticeable that ecocide is already typified as a war crime under Article 8(2)(b) of the Rome Statute, which provides for the crime of intentionally launching an attack in the knowledge that such attack will cause widespread, long-term, and severe damage to the natural environment, which is excessive in relation to the concrete and direct overall military advantage anticipated. Common features of international crimes are that they have great gravity, impacts that cross borders, or that they shock the conscience of humanity. In considering ecocide suitability for international criminal law, we can readily acknowledge that there is an increasing recognition that some of the most serious types of transnational environmental offences impact on the peace and security of mankind, as well as violating customary rules and universal values, thus satisfying the first three criteria. Significantly, the UN Security Council recognized in 2007 that climate change poses a threat to peace and security of mankind. The growing conversation connecting the environment with our human rights shows that these linkages are increasingly pertinent from at least an anthropocentric perspective. However, the accelerating damage to our global natural environment and climate, with causes and effects manifesting from many sources and actors, shows that international law is dealing with consequences of the highest magnitude. In the context of today's discussion on universal legal protection, therefore, international criminal law's explicit scope may be considered highly relevant. Ecocide law has been promoted since the 1970s at numerous high-level conferences, such as the UN Stockholm Conference on the Human Environment in 1972. It's been subject to various judicial formulations, and it was also debated amongst the International Law Commission regarding the draft codes of crimes against the peace and security of mankind. Today, however, there is accelerating support for the international criminalization of the crime across multiple sectors, and the law has also been discussed at governmental or parliamentary level in over 25 countries, with many more behind closed doors. The Council of Europe Assembly in Strasbourg has voted overwhelmingly, with no objections, for the adoption of resolutions 2477 and 2246, which both call for recognition of ecocide. And at this very moment, trialogues are occurring within the European Union over the inclusion of ecocide level crimes within the forthcoming European Crime Directive. Ecocide law therefore maintains a strong pedigree and awareness in international conversations. Its basis in existing international environmental law principles, such as the severe, widespread, and long-term terminology, reflects a previously established framework, while the crimes conflation of all elements of the environment at the highest level can reflect the foundational piece I mentioned is absent previously. While the crime is by no means intended as a silver bullet, the possibility of a uniform standard across states, necessarily enforced at different levels of courts according to the principle of complementarity, is already facilitating a new collective consciousness around the protection of the environment as well as its categorization in law, moving from civil disturbances to immoral acts. Regarding the universality elements at hand in today's discussion, however, as well as their implications for geoengineering, it's necessary firstly to consider ecocide's law's relevance to appropriate regulation of the environment itself, and how this may play out in the context of global and local regulation of environmental resources. The ecocide definition largely reflects a natural commons approach, where the environment and its regulation is conceived as a relational and dynamic system composed of a web of interdependent relationships between humans, non-humans, and the planet. The things or resources classified as natural commons thus form part of a whole called common heritage, which we've already heard reference to today. By including them in this heritage, they can be collectively managed with the purpose of preserving them. Such a perspective conceives law's role in environmental protection distinctly from the existing individualistic dichotomies between subject and object, or exploiter and exploited, towards relationships of solidarity. On a global scale, the international principle of the global heritage of mankind, applicable to what Roman law termed res communes, i.e. the property of all, with the characteristic that they may not be subject to the sovereignty of another state, as we've heard, such as the high seas and outer space, is apt to ground the global shift in attitudes towards environmental protection. This term mankind reflects an interspatial and intertemporal concept representing all people of the world, also reflecting principles such as intergenerational equity and universal solidarity, which are integral to the attitude-based element to ensuring exacting environmental protection. Despite perceived tragedies of the commons in the global scale, referring to individual overexploitation amounting to a collective loss, there is significant merit in not turning to further commodification, but rather for understanding what makes for effective management and protection of common resources. There's been a resurgence of interest in community-based conservation and resource management systems, using customary practice and local knowledge. And it's no coincidence that indigenous communities are guardians of roughly 80% of the world's biodiversity. The Bolivian constitution, for example, interprets the commons as a social right. And from the perspective of indigenous and local communities around the world, the emphasis on resources and relations to things held in common ownership is critical, where community and relation with nature are highly intertwined with ideas of the commons. It's interesting to note that research on management of the commons at both local and global scales reinforces the indispensability of governmental support for success. For example, in a discussion of the marine areas beyond national jurisdiction, it was argued that, ideally, a central international governing authority would apply the same policies and rules to all countries' activities in the ABNJ, which would likely produce more coherent and more consistent results than a Paris-style system of each country formulating its own policies and submitting them to a central authority for review. It was further highlighted, however, that hybrid governance models, or smaller regional authorities, are also effective when they include strong reporting and enforcement requirements. In this light, a well-defined environmental crime that's applied at cumulative enforcement levels could well combine these mutually reinforcing top-down and bottom-up processes at national and international levels. From the perspective of international processes, such as implementation of the Sustainable Development Goals, explicit interlinkages between local and global processes is essential. From the perspective of local and global collective heritages, destruction of which may well invoke numerous overlapping environmental issues, a robust and comprehensive framework rooted in adequate transparency, enforcement, and impunity is similarly vital. Criminalizing actions with the potential to affect any of these resources at its source shifts our current framework from the polluter pays to the polluter does not pollute, freeing time for the adaptive and multi-leveled regulation necessary for effective environmental governance. As I emphasized earlier, Ecocide law is not intended to govern all environmental resources. However, it can provide a clear framework for all, with an upper limit of safety that can provide the adequate space for other processes to unfold. Environmental regulation that reflects local rights and can ensure protection of local and global common resources is fundamental in the context of geoengineering deployment, as is a firm limit of permissible action. Geoengineering's interaction with Ecocide law is obvious by definition. Any attempt to implement geoengineering, which by the IPCC definition is deliberate large-scale manipulation of the planetary environment, may in fact result in severe and either widespread or long-term damage to the environment. Thus, those operating in these practices in countries with an operative Ecocide law may face potential liability. While I can appreciate the sentiment of leaving no stone unturned when it comes to ecological remediation, geoengineering, amongst other significant threats and uncertainties, which we've heard about today, presents a specific governance challenge. Technologies of geoengineering present very differently from one another with respectively different obstacles. Within the realms of such uncertainty and complexity, it's thus vital to ensure that any measures deployed exist within our planetary boundaries and are regulated firmly as such. The uncertainty as to the impacts of geoengineering on complex planetary systems, such as global commons, as well as the irreversibility of these potential impacts, evidently makes precaution relevant, as does the risks that these technologies create in exacerbating global power imbalances, environmental catastrophes themselves, and also human rights violations. Moreover, such practices also entail a real risk of creating a cover to avoid effective nature-based solutions in the hope of quick technological fixes, potentially locking in the systemic drivers of the crisis and exacerbating a worrying trajectory. As discussed, greater transdisciplinary and geographically diffused research is required to understand the implications of geoengineering itself, as well as its wider connections to implementation of other international processes. As Lily and Christina both mentioned in earlier sessions, there are restrictions on the development and deployment of geoengineering already adopted by states in the Convention on Biological Diversity, the 1972 London Convention on the Prevention of Marine Pollution, as well as its London Protocol, and the Monterey Protocol on substances that deplete the ozone layer. However, as I noticed previously, for issues in procedure, there are considerable disadvantages in relying solely upon state-based liability in the context of environmental resources. This framework isn't enough in the environmental context thus far, and arguably it's not enough for the geoengineering context. Ecocide law is concerned with situations where evidence shows that an act or omission was unlawful or wanton, committed with knowledge, and where decision makers might appropriately refrain from action due to their knowledge of the likely outcome. Ecocide law may therefore be directly and indirectly relevant to geoengineering, posing an alternative action to limit it. While large geoengineering practices may risk a commission of the crime itself for the reasons just discussed, Ecocide law can also provide indirect protection against the worst of its effects, with a strong definition predicated on universally protecting the Earth, species and non-species, and outer space, enabling the facilitation of the appropriate protection of resources most at threat from the crises, and potentially geoengineering itself. Geoengineering poses a particular threat to our global commons, in particular the largely unregulated area of outer space, which we are quick to forget is also composed of fragile ecosystems. The governance gap in respect of geoengineering poses widespread concern over the lack of international governance and oversight regarding research into and deployment of such technologies. Given there's currently no international treaty regime which specifically addresses the practice, it is also evident, however, that the practice is relevant to numerous overlapping legal fields. Within this confusion, Ecocide's law's definitional and substantive benefits, as discussed previously, could hold great promise. There is a critical necessity to protect the global commons as common goods of humanity for present and future generations, and enhance the role of courts at national, regional, and international levels to apply environmental standards from international policy considerations. We could say we need more courts and fewer reports. These processes are arguably crucial to preventing negative implications of geoengineering technologies. In this light, by emphasizing the responsibility of key decision makers, Ecocide can provide a useful cross-sector outer boundary through which to examine business practices, prevent the most destructive projects, and invoke investment and action in more sustainable practices. Clear rules can be of benefit to all societal sectors, with a firm root of common and non-derogable standards and responsibilities. We would be wise to reflect on the potential consequences of further playing nature and put limits in place to ensure that any such developments are no longer reflective of a one-sided relationship. Protecting our planetary boundaries protects our peace and security, and the breaking point between our discussion on these developments and our action to ensure its sustainability is enforceable law. Thank you.